Importance of arbitration in the present era. It is very important for all of us to know about the importance of arbitration in the present era, because arbitration is increasing day by day. As the large and big companies who have name, they will not go for the court proceedings at the first instance, but in that clause they will put arbitration clause in their agreement. And in case of any dispute between the firm and between the parties in related to commercial disputes, the parties will not go and approach the court first, but will approach the arbitration first to resolve the dispute. In the terms which they will save their cost, it will be very flexible for them and quick decisions. So already our court is overloaded with lots of cases, so arbitration plays an important role in the justice delivery system and ensures that justice is given to the parties and conflicts are resolved out of the court. Step by step process we will understand about arbitration. So first of all, arbitration is an out of court settlement where a neutral party, that is the arbitrator, has been appointed by the court, or if the parties have previously been decided, then in the arbitration clause mentioned in the agreement the arbitrator name is already mentioned. If not, then according to section 11 of the Arbitration and Conciliation Act, the high court and the other court, who is the power, will appoint the arbitrator, and the arbitrator will decide the dispute between the parties. So in this case, the parties will ensure that their deliveries of our justice has been given at the first instance and their reputation has been saved. So arbitration protects the interest of the parties and resolves the dispute with less time and ensures that parties name and reputation is also being maintained, because in civil cases lot of time the court will take to dispute and to resolve the decisions and to give the decision as earliest, because the pendency of case in our country is a huge backlog of cases we have seen in the recent days. So arbitration is a much relief to the courts also, and justice to the parties is ensured at the earliest. So arbitration proceedings are ensured that a arbitrator has been appointed, the parties will arbitrate, and the parties will get a good decision in the favor. And if the parties are not satisfied with that decision, they can approach to the high court in case of international arbitration, and in case it's case of domestic arbitration, then they can approach to district court to set aside the arbitration decree. And that is the section 34 of Arbitration and Conciliation Act, which talks about this thing. Then they can approach the court if there is a clear violation of law. First point. Second thing is that the parties are incapacitated, they are not able to contract. Second point. In that case, the arbitral award can be set aside by the superior courts. So, Section 34 of Arbitration and Conciliation Act talks about this thing. Thank you so much.
Like, comment, and subscribe.